Well, hello, everybody, and welcome to this episode of Divorce Explained. It's Steve Benmore, and I'm here with my colleague, Leanne Townsend, and we're excited today to discuss a recent case that I read that was, let's just say, provocative. And it was a decision by an Ontario judge by the name of Justice Presser, released in January of 2025, January 20, 2025 to be precise. And today we are interviewing Rebecca Yee and Barry Nussbaum, who were the lawyers for the applicant. Now, for the purposes of protecting the identity of the people involved, the name of the case is SM versus RF, and the citation is 2025 ONSC 4155. Now, we're discussing today the subject of annulment of marriage, for example, as opposed to a divorce. And this is a situation where Barry and Rebecca were retained by a man who said to them, lawyers, get me an annulment. And get me an annulment. Why? Because my marriage to my wife was not consummated. And I can only imagine that Rebecca and Barry said, please tell. And then the conversation unfolded. And we're going to get into that today. But let me just begin by letting you know that I have been reading case law for 30 years. And I find most cases marginally interesting and almost of very limited value for a Hollywood movie. This one jumped out at me, and we will get into why in a moment. But I want to now turn to Rebecca Yee, who was the successful counsel for the applicant in this hearing for an annulment. And I'd like to ask you, Rebecca, if you could just tell us what was going through your mind when you first heard the case that was going to become your case, which later became a trial, which later became a judgment. Let me know what was in your brain right at the very beginning, kind of around the first consultation stage.
Yes, well, thank you, Steve and Leanne, for having me on this podcast. It was definitely a very interesting case. So when the applicant had first approached us and wanted to seek an annulment, I'm usually quite skeptical. That's usually my first thought. As you may be aware, a lot of annulment cases are not very successful, and there are very few annulment cases. Most people just proceed with the divorce. And so when the client wanted to seek an annulment, I was very curious to see on what basis. And when he had said that it was on the basis of non-consummation, I was even more curious. So with the law non-consummation, it's very, I think a lot of people get confused. It's not so much that there was no consummation, as that one or both parties were unable to consummate. So there's that distinction. And so when the client had approached us and had said he wanted to seek an annulment based on non-consummation, I really had to get the details as to whether or not it was just the fact that they didn't consummate or that they couldn't. So it was definitely an interesting conversation with the client, and we had to go into a lot of details on very intimate, the intimacy of the relationship. But it was very fascinating. So it was definitely something that I was excited to argue for the client. And I would say that it was, I was just more so curious about the case and very fascinated by it.
And Barry, you and I have been doing this work for many, many years, and we are aware that in the area of family law, our clients are extremely cost conscious. And so when they come to us, they want to know what is the shortest distance between 2 points. And I can only imagine when you and Rebecca were discussing this case, you must have turned your mind to, wouldn't a divorce be a lot faster and a lot cheaper. Why go the route of annulment other than the divorce? And was this driven by social stigma? Was it driven by not wanting to invoke the property laws or the spousal support laws in Canada? Was it partly because for religious reasons, the client didn't want to go back into the marketplace and say that they were previously married? Like what factored into the conversation about the economics leading to the pathway that you chose?
I find with annulments, it's rarely about economics. There was in my practice, I can remember one or two cases that it was about the economics of it in terms of equalization owing. Usually, it's the either the religious, which is very often in the Catholic faith, and the fact that they're allowed to get it legally. It's not necessarily social. More what I want. Marriage wasn't consummated, and I want to get an annulment. And then I explained to them that, as I'm sure you both do, that it's not as straightforward as a divorce, and the judges can be more picky about it, but it's not the most expensive procedure. And if you want to give it a shot, you can certainly go for it. And I give them legal advice with respect to that.
Now, what I thought was interesting when I was reading the comments by Justice Presser, and maybe Rebecca, you could elaborate a little more on this, is she actually, she outlined in her judgment that can be found at the site that Steve mentioned, that the applicant husband was, making certain arguments with respect to the cultural component of annulment versus divorce. And he seemed to be saying that in the Indian culture of this couple, that a divorce would actually have more stigma than an annulment. And the respondent wife seemed to be arguing that no, the annulment would have more stigma because if she'd had any sort of sexual relation with a man who wasn't her husband, there would be more stigma with that. And then it seemed that Justice Presser said that, for the purposes of her decision, she didn't really need to decide on that issue. She's purely looking at the legal test. And so, whether and there was no expert evidence or any evidence on the actual cultural implications. So I'm just wondering if you could elaborate a little bit more on how culture does or doesn't play into the legal test.
Yeah, so for the applicant, our position was very much that the legal test is the legal test, and any sort of cultural or social influence should not have a factor in how the judge determines what the test is legally. And so the respondent in this case was very much trying to argue the cultural and social implications for her future marriage prospects and just kind of how she'd be viewed by society if an annulment were to be granted. And the applicant's position was that none of this is relevant for determining legally whether or not there's a basis for the annulment. And so we are very happy with Justice Presser's decision that the cultural and social factors really should not impact the decision. In terms of expert evidence, so we actually did, one of our witnesses for trial was actually an imam, and he gave evidence on more so the religious component of things, and he was directly involved with the couple. He was speaking with both of them. So he was able to give some evidence on sort of the religious component. And one of the evidence that he gave was that being divorced really doesn't have the negative impact that the respondent was claiming to have potentially in the future. So I think that evidence was very helpful for the judge as well.
Can I say something? The actual law that your case comes out of is the Annulment of Marriages Act, which is provincial legislation in Ontario. And I actually read the legislation. It took me 10 seconds to read the entire statute. It's got 3 sections, and the only section that deals with annulment is the middle section, section 2, that says the law of annulment is the law of annulment in England from 1870. And so, pardon me for wondering, how is it that we live in a province of a country that simply says the law for this thing called annulment is not our law? We're gonna borrow the law from the UK. Oh, and by the way, we're gonna borrow it from 150 years ago. Mm-hmm. And so when I read your case and I read your the recitation of the various Ontario decisions over the years that gave meaning to that, I couldn't help but think, where is the development of the social mores, social norms? Because presumably the word consummation leading to an annulment in 1870 has got to have a very different meaning today, because there are people today that marry 2, 3, 4 times. There are people that marry who do not have sex. There are people that marry who marry for companionship. There's in Canada same-sex marriages. And so this notion of consummation from the UK of 1870 seems to me to be a very outdated notion. And when I read the facts of your case, Rebecca, your couple were dating. Their parents introduced them to one another. They had a lavish wedding. They had not 1, 2 honeymoons. There was the purchase of lingerie. There was hugging and kissing. And there was, and I hate to get into the details, attempted intercourse where the judge heard evidence, presumably you let it, about how deep the penis went into the vagina. Pardon me for wondering this, but, Pierre Trudeau once said, there's no place for the state in the bedrooms of the nation. And so the fact that you took a case, you built a case surrounding a claim for annulment on the basis that the penis only went in so deep, I find that whole thing to be very bizarre. And you were successful, and kudos to you. But is that not consummation?
So the law on consummation is very old, as you were saying, and there's very few case law on consummation. And so I'm very impressed with how the judges are able to make decisions on something with very few case law and very few precedents. So with the non-consummation issue, I think there's a handful of cases that are available, and it really was up to Her Honor to make a determination on what constituted consummation. And so there was one case law which had said that consummation had to be complete. The word was complete. And so Her Honor had to really determine whether, based on the evidence, whether or not a percentage of the penis going in constituted a complete penetration. And so given that was the law and that's what we were relying on, Her Honor had made that decision that halfway or 10% or whatever the insertion level was, that it did not constitute complete penetration. So we didn't have a lot to work with, but what we did have was very limited, and we were really leaving it up to the judge to determine whether or not the facts of the case really warranted an annulment.
And this is one of those cases where digital evidence was relevant because the communications between the parties did reflect the fact that the wife, who was opposing the request for an annulment, more or less admitted that they were not able to perform full sexual intercourse. And so you actually had sort of an admission from the respondent wife that consummation did not occur. And so from what I could see, the judge brought into 2025 the recognition that consummation requires full penetration of the vagina, not partial. And that's how detailed the judge got with respect to the interpretation of the word consummation. And so, Barry, when you read the decision, did you not nod your head?
Yep, I certainly did. Definitely wasn't expecting all of that detail. I think what you quoted from Prime Minister Trudeau was spot on. He probably would have appreciated reading it himself because that's what basically he was speaking to.
I thought it was interesting because Justice Presser actually, I think, even mentioned that the definition of consummation by the courts, maybe somewhat outdated because she was referencing how it mentions a cisgender, male and female, which, in 2025, because we do have same-sex marriage and whatnot. So that definition wouldn't apply in a same-sex marriage, but it wasn't, for the purposes of the facts of this case, she didn't need to go further and elaborate more on that. But I thought it was interesting that she did comment on it. One area where I have some question, and I think our listeners might find it helpful to get a little bit more information about, is because I haven't done a lot of annulment cases, so this may be something the three of you even have more experience with. But it seems to me that with the test, part of the test is was the marriage consummated, and then if the answer is yes, then that ends it. But if the answer is no, the second part of the test is, if the marriage is, if it's incapable of being consummated. And so it seems to me that if one of the parties is just refusing to consummate it, that they're both capable, but one is just refusing to have sex, that doesn't meet the legal test, and a person can't. So if someone gets married and then their partner just says, no, I'm not interested in sex, I don't want to have sex with you, and I'm never going to have sex with you, but yes, I'm able to, that someone couldn't get an annulment on those grounds. They would have to go the divorce route. And so I'm wondering if you could elaborate a little more on that, because it does seem to me almost unfair for somebody that goes into that situation and then finds out that their partner just refuses to have sex and they don't qualify for an annulment.
I'll just, if I could speak to that first, and because I was reviewing the case law on it last night again, and it's very nuanced. And the example that you gave, Leanne, the person who said, I just don't want to, I believe from my interpretation of the case law, he or she can say, because I mentally can't do it with you. It's not that they can make that can be their argument. I'm able to with another person, just not you. I'm disgusted with you, or I just can't. I can't go there. So that's how they would get the annulment. I think that's how the courts, how they can get through that issue.
It's more like a psychological, I guess, barrier that they would be relying on, rather than just I'm refusing to. Right.
Like I think if they got up on the stand and said, "Oh no, I'm attracted to you, no problem. I think you're a sweet person and very nice, or a very nice guy, and I just don't want to." Yeah, the judge will throw out that annulment case. But if they say I'm disgusted by you, I can't go near you, I can't mentally go there, I think that they would be able to get an annulment.
That's interesting.
I think in that example, though, it's very rare, because I think usually somebody is opposing the annulment. Usually it's one party seeking it and the other person opposing it. So in a situation like this, where the one person doesn't want to have intimacy with their partner because they just psychologically cannot, in a situation like that, if they're admitting that they have the psychological hindrance to consummation, then usually it would be on consent that they would get the annulment, because it would usually be the other person that is not receiving that intimacy seeking the annulment. And if the person is admitting that they can't have intimacy, then in a situation like that, usually it's on consent. And of course, it's ultimately up to the court to decide whether to grant it, even if it is on consent. But usually the person doesn't admit that they have a physical or psychological barrier to consummation. But speaking on that, in terms of not being able to consummate, it can be physical or it can be psychological. So in this case that we were arguing, the applicant was not arguing physical barriers. The respondent did seek physical checkups and confirm that there was no physical barrier to consummation. It was purely psychological.
But even on the psychological side, all of the emails and communications seemed to suggest an effort to keep trying. Mm-hmm. They went on a second honeymoon and they kept on trying. It wasn't like it was she said, I do not want to have sex with you, I'm turned off by you, or that I'm afraid of sex. It was just that they just weren't able to get there yet. And again, this is obviously a very traditional and religious set of spouses. She was a virgin. I think he was a virgin. So this is a very unique for the general public, but it's very general for that very specific category of prearranged marriages between people that are virgins. And so my question to you, Rebecca, is that if the wife took the stand and said, yes, he wasn't able to get fully into me, but I spoke to a pharmacist, they told me to use jelly, and that if we keep on at it, we might be able to actually begin having sex. Would that have changed the outcome?
Potentially. I think it could have, because in this case, they only attempted consummation once, and that was on their first honeymoon. And even though there was evidence that, there was lingerie purchase, there was other items purchased to try to facilitate that consummation, it wasn't able to occur. And that only furthered our argument that there must be something preventing it from occurring. It's clearly both parties are willing. It's just what is now stopping it. And so our position was that this confirms that there was some psychological hindrance to the consummation. And so in this case, they tried it during the first honeymoon, and that's where there was, some penetration, but not complete. And then they stopped. And since then, there was no other forms of penetration. And the evidence that was presented was there was a lot of anxiety, fear, stress, anytime there was any sort of intimacy. And so because of that, Her Honor had made the decision that there couldn't have been consummation, even if they had continued to try. And they were married for 2 years, and they tried, and there was still no consummation. But in the example that you're giving, if there was evidence that showed that they were doing all that, and there was even medical evidence that said that perhaps they could have gotten to that point, then I think that could change the outcome, but I can't be sure.
Thank you. Barry, you and I are both Jewish. You and I have both been to many, many Jewish weddings. We've had our own weddings. Can you tell our listeners how the Jewish faith deals with consummation, literally right after the rabbi declares that they are husband and wife under the canopy called a chuppah? Please tell our listeners, what is that thing called the yichud room?
Right. Okay. Because I was fascinated when I read that in the decision. I always say when family law, this comes up all the time because it deals with marriage. I'd say it's more than similarity. The religions are almost akin in how they deal with marriage and divorce, and they have the mahar and they have the ketubah. In any event, yes. So we have the same thing. In fact, being someone who learns the Talmud regularly, so there is a tractate, as we call it in the Talmud, that deals with marriage, and the first page of it, which is always what you remember, and I learned it in grade 12. That's what we learned, and it talks about the 3 ways to get married, and one of them, what we considered legally married. So, and one of them is exactly what you said, Steve. So the yichud room, which yichud means seclusion, and the man, husband and wife, after they finish the ceremony, walk with joy with their friends and their family, dancing them to a room, and they have to be there for a certain amount of time alone, which enough time to consummate a marriage, 7 minutes, whatever the time frame is, and that is enough to be considered legally married under Jewish law. Parenthetically, the other way is to physically consummate the marriage, which is the other way to get to be physically married, if you just do the deed. And the other one is the actual ceremony under the huppah. So what we do nowadays, we satisfy all 3 opinions. So, as you know, the joke, 2 Jews, 3 opinions, right? So there's differences of opinion. So we satisfy all 3. We go to the huppah, we go to the room, and of course the couple naturally consummates the marriage at a later date. So yes, that is the yichud room.
And for the benefit of our viewers and Rebecca and Leanne, almost every Jewish wedding I've ever been to, so they're under the canopy. They go through all of the blessings and ceremonies, and then they break the glass. And then the bride and the groom turn around, walk back down the aisle, walk out the door, everybody's clapping, and then they go into a private room where they are supposed to have sexual intercourse. And there are supposed to be 2 guards, usually 2 of the ushers, who stand at the door, guard the door, so as to not let anybody interrupt their consummation. Now, I hope I'm not speaking out of turn here, but the vast majority of brides and grooms who just walked past 300 people down over there, and they're about 10 minutes away from a huge party right over there, while the woman just spent the whole day preparing her hair, her makeup, and she's wearing this big puffy white dress, they're not exactly having sex. But the tradition is that, Jewish tradition that is that consummation through sexual intercourse is a necessary ingredient and a prerequisite to establishing the marriage. And as Barry said, there's lots of commentary on this. When exactly were they married? Were they married under the chuppah? Were they married after the consummation? I mean, there's all that. When I got married, I was already married before I got married because we had to go down to City Hall and get the Ontario marriage certificate, which effectively meant I was already married before my wedding. And so by the time I even got to my Jewish wedding, I was already married under Ontario law. And then I got married under rabbinic law, under Jewish law. And then let's just say that for those that are already tuning into this very provocative topic, some Jewish people, before they get married, had premarital sex. So there wasn't any reason to wonder whether there was a psychological or physical disability. So the point is, consummation occurred both before the wedding and then after the wedding. So, but when we talk about the legislation from England from 1870, clearly there are still pieces of that are still applicable today. And one can only wonder, and I'm going to ask you, Rebecca, if tomorrow somebody walks into your office and says, we've been together for 5 years, And if I had to pay an equalization payment, it would be worth $1 million. Oh, by the way, we never had sex. And so you go the route of a divorce, your client's going to pay an equalization payment of $1 million. You go the route of divorce, of annulment, your client does not pay that, and you use non-consummation. So now you're going to have a conversation about why did you not have sex? Tell me what you would do with that scenario.
Well, it would be similar to how I was with this client. So I would have to figure out on what basis is the non-consummation. Is it just because you refused, or was there an actual physical or psychological barrier to non-consummation? And just because the client wants consummation or wants to make an argument for an annulment based on non-consummation, I think it's our job as lawyers to give them realistic legal advice on what their chances are at success in the case and the cost and benefit to pursuing that argument. So if this client really has no basis to seek an annulment, but they insist on it, then they're potentially setting themselves up for cost consequences. And it would be more worth it to just pursue a divorce if they have no basis for that argument for an annulment. But if they do have some evidence to suggest that there is a physical or psychological barrier to consummation, then and their instructions are very clear that they want to pursue this, then we will, of course, take their instructions and do our best to argue the case.
Well, this has certainly been an interesting and provocative topic. And on behalf of Steve and I would like to thank both of you, Rebecca and Barry, for joining us today on Divorce Explained. I think you've provided some really helpful information to our listeners. So thank you so much.
Thank you for having us on.
And thank you to our listeners. Please join us here again next time on Divorce Explained.